working on agenda item number 8. So, and we were, do you want
So I think we had begun to. Oh, I'm sorry. I apologize.
So I think that Ruby had given us sort of a perspective of the day to day, and I think it would do well for public members and myself to hear from the other two professional members of the board, so that we can sort of understand what client patient interaction really looks like. If you wanted to add anything.
I think you summed it up pretty well. I mean, like there's like physical hands-on contact. There is times when we might find ourselves alone or removed from other people, and then I think we deal with financial and also personal information.
I think you guys pretty much covered it. I'm trying to think back to like when I was with Exotica, and I remember the only thing was they did share like staff between the doctor side and the optical side. So then the staff out in the store would actually pre-test patients and do things like that. So that's kind of like that is kind of the degree, um, as well as the back lab work. But if you're talking about patient interaction, I mean, you can be in a pre-testing room with a patient.
Yeah. Oh.
I just have a question. The pre-testing room, is it dark in there as well?
Very dark.
Yeah, so I think that's insightful. The examples you've given, it sounds to me like they are probably nearly identical to the concerns, or at least a subset of the concerns the Board of Optometry would have with respect to optometrists. And so maybe, so I'm thinking out loud, it's like, oh, should we just defer to the board? Since they're the ones who are going to make this regulation anyway, or should we wait to see what theirs are? Because it would be really embarrassing if we suggested ones, I think, that were more strict than the board came up with to apply to optometrists who might be in similar situations in terms of like the financial crimes, the exam room stuff, that the intimate contact, that sort of thing. So I don't know, strategically, like if we want to give our 2 cents with respect to specifics on this, or maybe the regulation's the same for the one that appears for us as well as for the Board of Optometry. But again, ultimately, it's going to be their decision.
So I think you could do it multiple ways. I think if there's no vote taken here, we want to add these specific ones right now. If you're not ready to do that, we have some input now from everybody. We can present that not as a decision, the final advisory decision of the DOC meeting, but when we present it to the board, these regs, we could raise some of those issues when they're going through these regs for. Also, I wanted to point out, even if the regs started as the bare bone package, they still go through a process and they can be amended during that process. So again, it's like a year-long process. There's a public hearing, 45-day notice, public comment. Many times boards will add things or change the regs as they go through the process. So that's another option as well. So you have a little bit more time, but it's in my view for the April meeting, if you want to stay on track with the DCA department's kind of timing guidelines to get things moving, you might want to just like Mr. Cassell is saying, is kind of delegate this ultimately to the board with your input.
Yeah, I think it's probably a good idea to stay on the April timeframe to get it moving. And I think we're almost statutorily required to recommend what I'll call the first draft that just has the basic 3 new elements to it. We could do that and maybe suggest to the board that that if people think that it should be consistent with the substantial relationship that optometrists have. Now, again, they might come up with even more stuff that when we would see it, we would say, well, that really doesn't apply. But I think that's probably the safer approach. And for the concerns that you all have raised that I have less of a concern with, I think that's what gets those included, because they're going to be what the board includes for optometrists, I imagine.
I would say that I don't think there's a need to be strategic about getting out in front of the board. That the board very much wants to hear from this committee and its expertise, and its feelings, conviction on what should be done for consumers. So I wouldn't consider as much the strategy or being concerned about getting ahead of the board. I think the board wants to hear your recommendations and what you feel is appropriate. That we can convey your comments, but if there are, strong feelings one way or the other, that taking a vote will make it clear to the board what your intention is. And I think that that's an important part of what you statutorily, as this committee, should be providing to the board.
So you want to go ahead and take a vote on our strategy at this point?
It is at the pleasure of the committee.
Sorry. I'll make a motion that we recommend to the board this draft section 1399.270, which just includes the new elements required by the statute and keeps in place the existing substantial relationship criteria.
Do we have a second to that?
I'll second that.
Okay. Now, do we have any discussion? And do we take public comment? Did we have any?
I was just kind of I was joking. I don't consider her necessarily the public, but do you have any comments? I just want to clarify that your motion is to not raise to the board any of the other concerns that were represented today. Your motion as it stands is just to
that we
keep
recommend putting
the
this
whole thing is as is with necessarily no additions.
to begin the rulemaking process,
Okay.
or the regulation process, whatever
Okay.
you call it.
All right. So we'll call a vote. Okay. So Adam,
Aye.
Anna,
Aye.
Bill,
Aye.
Con,
Aye.
and I vote aye. So now we move on to, we skipped, I don't know if you want to go back.
Actually, we have to. That was only substantial relationship. This is the rehabilitation criteria also needs to be amended, and what I'd like to point you to is from the legal department memo on page 10. I'm sorry, on page 9, the legal department memo.
Page 10.
Page 10 of the legal department memo.
Technology's making things so easy.
And I wouldn't say that
Oops.
yes, the actual page of the memo, not the PDF.
Right.
And then in addition, if you, I don't know if you could also pull up the additional PDFs that are for the rehabilitation criteria.
That's the language in markup.
It's actually the current, your current regulations on it. Does everyone have that?
Is it that one Title
Ti-
16 Division 1 13.5?
1399.2.271 and 272.
Oh yes, that.
Does everyone have that?
Yeah.
Yeah.
Okay. So I just wanted, for this one, I wanted to start with what the current law says on this, and then actually read to you the section that deals with rehabilitation, how it's changing. So under the current statute, Business Professions Code 482 says each board under the provisions of this code shall develop criteria to evaluate the rehabilitation of a person when, 1, considering the denial of a license by the board under section 480, or 2, considering suspension or revocation of a license under section 490. And then it says each board shall take into account all competent evidence of rehabilitation furnished by the applicant or licensee. That section so it says each board shall develop criteria. The board has already developed, it was the medical board that developed the criteria that you're looking at that are these regulations, okay? So now the AB 2138 has changed that particular statute to say each board under this code shall develop criteria to evaluate the rehabilitation of a person when doing either of the following, and the 1 and 2 are the same, of considering the denial of a license, 2 is considering the suspension or revocation of a license under 490. And this is where it changes. It says each board shall consider whether an applicant or licensee has made a showing of rehabilitation if either of the following are met. Number 1, the applicant or licensee has completed the criminal sentence at issue without a violation of parole or probation. And then 2, the board applying its criteria for rehabilitation finds that the applicant is rehabilitated. So it's legal minds have decided it's not clear, and regulations are needed to kind of flesh that out. And what the legal department memo did was they looked at the legislative history, and they came up with 2 proposals for what they thought would be regulation amendments that would comply with this. And when you really were talking about the first one, for the number 1 that says the board shall consider whether the applicant or licensee has made a showing of rehabilitation if, number 1, the applicant or licensee has completed the criminal sentence at issue without a violation of parole or probation. One option that is in the legal department memorandum is that the board would say, okay, has there been a completion without violation or parole or probation? And if there has, then that's a showing of rehabilitation. You don't look any further. The second option, which is also found to be within the statute, is that you can look at number 1. You have to look at it first alone, because whether there's been a showing of rehabilitation under number 1, but you still are considering the rehabilitation. So you're not limited to, okay, if they've completed without a violation, they're rehabilitated. So the second question is, then what are you doing? What factors are you looking at if they've completed without a violation? So the reason why I wanted you to look at page 9 of the legal memorandum is because the factors that would be considered under the first prong, whether there's been a showing of rehabilitation because the applicant or licensee has completed the criminal sentence at issue without violation of parole, is that the board shall consider those first 5 factors: the nature and gravity of the crime, the length of the applicable parole or probation period, 3, the extent to which the applicable parole or probation period was shortened or lengthened, the reasons the period was modified, the terms or conditions of parole or probation, and the extent to which they bear on the licensee's rehabilitation, or applicants in that case, and the extent to which the terms or conditions of parole or probation were modified and the reasons for the modification. So this was some factors that kind of the department just came up with based on case law that I believe dealt with criminal, deciding whether a sentence should be, probation should be reduced. So they kind of pulled that from some case law, but it's not, and for consistency, these are the factors that were kind of recommended. But in speaking with Ms. Crawford, she's identified some issues with those factors. So we are trying to come up with maybe different factors. And she could speak to some of the issues with those factors, but we kind of want your input, first of all, on the statute and how it reads. The board in their last meeting decided they didn't want to go with the option where they lose their discretion. They're just looking at whether there's been a completion of parole or violation without probation, and if there has, then they've been rehabilitated. They want to keep the discretion and look at some other factors. So that kind of option's off the table unless you feel strongly, and it would go back to the board as your recommendation that they look at that for opticians. So let's see. With that, can I turn it over to you, Anahita, or do you want?
Do we want to allow discussion on whether or not there's that need?
of looking at the second factor? Well, yeah, why don't we talk about that first? Because I think, again, we're going to have to say that we looked at the options and decided against them. So is anything, I know this is very difficult because it's very legal, but is everyone on the same page with what's going on with the statute?
Yeah, it's perhaps equal parts disheartening and empowering that this question is being put to the advisory committee of a board within the Department of Consumer Affairs. This is a pretty threshold question. Either somebody's going to, of course, eventually sue on this and say, no, I finished my probation, so I'm entitled to. And then there'll be a court case deciding whether that or is an and or that or is an or, and so forth. So it's great that we get to give our 2 cents, but in reality, this seems like really a decision above our pay grade, so to speak. At this level, especially since the board we advise kind of has already taken a position on that.
And that position was one that was, again, the legal department memo reviewed by the AG's Office of Administrative Law, felt that either option would be complying with the law.
Right. And so it's like, for me and what we're doing, the consistency matters. That if we have an optician who is deemed not rehabilitated, but a podiatrist is rehabilitated, it seems it could be kind of inconsistent and unfair as to,
you're
how
saying
you
if different boards
right,
pick different options.
Right. And so that's what I'm saying. It's disheartening because you'd think that there would be a consistent approach on what it would mean. do we have, so the Board of Optometry came up with their criteria for
Now, the Board of
optometrists?
Optometry, all they've decided so far is that they don't want to go with the second option, which was, remove discretion from the board to evaluate other factors of rehabilitation if the licensee or applicant has completed their criminal sentence without probation. That's all they've decided. So they want the ability to review other factors, other.
But they're going to have to, they will have to come up with those criteria.
They will
the
either
same
have
way
to
we are going to
take the
recommend.
criteria that's been as the template for all boards and bureaus, or look at these other. How else can you structure this? What other factors, in addition to this or separately from these 5 within that first criteria, are relevant? So again, if you're saying that the board retains discretion, even though the applicant or licensee has finished their sentence without a violation, the board still has to determine, is that enough for rehabilitation? The next question is, well, your regulations have to have some factors to what are they going to look at? So
Right.
this is where these came up with, okay, if you're talking about parole, well, if the parole was short, maybe it's it doesn't show rehabilitation.
But it's also theoretically possible that you could be, it's a question maybe. Is it possible that you could be rehabilitated for purposes of licensure or registration, but still have 2 more years of probation to go on your criminal matter?
I think under the current regs, am I right that is the length, whether the terms of probation and whether they've completed probation is just one factor for rehabilitation?
It is one factor, but I think your question is, can they be currently on probation and be deemed rehabilitated? And I believe that. Oh, I'm sorry. And I believe that this criteria would only apply when the applicant has completed probation without violation. Then this criteria comes into effect as to now are they rehabilitated?
Okay.
Just a question of clarity. Do you think they're bringing this to us because we do have some that are SLDs are applying for it and they learn their trade in prison? Is that why we're...
No, I
That
think,
has to
I
be
mean,
done.
all boards are going to have to revise
that,
their regulations, and so the board's probably going to say, well, what did the DOC recommend, or what did they think it was the best approach?
Is there going to be, are there going to be 2, like one for optometrists, one for opticians?
Yes, because the optometrists have their own regs
Yeah.
like that. These are just for opticians, but I think to Mr. Casella's point is, will the board want them to be consistent, or are there differences in the practice areas where they should be different? I'm sorry, did I say they'd want them to be consistent?
Right. They philosophically, they may say, there's nothing to worry about with opticians. If they served their time, they're rehabilitated. But optometrists, we want to make sure, in addition to serving their time, they meet these 4 things. But given that we had just talked about the kind of the nature of the concerns of the substantially related crimes, are probably for the most part similar between opticians and optometrists.
Yeah.
Whether it be the financial crime of insurance fraud or being a sexual predator or whatever is deemed to be substantially related, or at least be put in the opportunity to further your past criminal endeavors, or being a recidivist.
And it would be up to staff to decide on, once these items are
And regulations.
in
yes.
regulation, it would be up to staff to
On
decide.
the application
right.
side to whether to grant. On the discipline side, then it goes through the process where there might be a hearing, a proposed decision,
Mhm.
and the board will then
Okay.
decide if the proposed decision they'd want to adopt it or not. But there would be an evaluation of that rehabilitation
staff.
and by staff on the front end for
Right.
applications, on the license discipline side by the ALJ and ultimately the board about rehabilitation.
I mean, it seems to me if we should allow for as much flexibility for the board to
Mm-hmm.
have those kind of decisions instead of it just being once your parole's done, you're good to
Mhm.
go. There are always factors that can come up. That's fine. And it seems like that's what they want, so why would we give them something different?
Okay, so and then that's the first one. Now, if we could talk about those 5 factors versus maybe some other factors.
What
Like,
would- yeah.
So right now, my understanding is that staff would be required to investigate on the front end to try to get all of this information, the information about the terms of and conditions of parole, whether they were modified, the reasons for the modification. My understanding from Ms. Crawford is that is not readily available in what they get right now. So there's going to be costs on the front end for staff for investigation of this. You could have another set of criteria where you're expanding on the nature and gravity of the crimes. For example, how many crimes are we talking about? How close in time? How do the crimes actually relate to the profession?
Well, these are only, I thought these were only for substantially related crimes.
They are.
This is for
This is
phase
all.
two. So
This
we've
is phase
already
2.
determined.
Everything's substantially related. Everything's within the statute, the new statute, and but now you're looking at, even with all of that, let's say it's a crime within, 7 years. Have they been rehabilitated?
I think the examples listed make sense. The only one I could think of, maybe it's just a modification, or maybe we can talk through and decide that it's covered by one, the nature and severity or gravity, whatever term they use, is a repeat. So if you did the crime once and did your time and whatever, then we'd be looking at these factors, whatever. But it seems to me you'd want that the board would want to know that you did it once, got caught, served your time, and you did it again and got caught and served time. Because now you're, when you talk about rehabilitation, it seems to me if you're a repeat offender, your rehabilitation has to be looked at with a little more scrutiny because you've repeated. Whereas a one-time offender, it's like, oh yeah, they messed up, made a mistake, whatever. But you'd want to know if they did it more than once. I'm not saying a criminal history, because it might be that whatever you did when you were 18 or 22, unrelated to the practice. I don't think that should be suddenly swept in because you have a history of being a criminal. But I think it's relevant if you have a history of being a substantially related crimes criminal, meaning the crime you're supposedly rehabilitating from right now. Do you think that that's covered in nature and severity? It might be covered in their punishment.
No, I defer to you, but I think that's a good comment. That might be something that we could add as one of the factors, both for the optometry and the DOC list.
Especially if it's like the first one happened 7 years in the past, right?
Well, that's a good point there.
and they
Maybe
would've-
some that are
right.
that would have
Right.
otherwise been invisible.
Right.
Yeah.
for these purposes.
Right.
The repeat nature of such.
Yeah, repeat nature whereby the first one happened 14 years ago and then happened again 4 years ago.
Right.
But you wouldn't know about the 14-year one, correct?
I believe that on the criminal background history check, we would know, but
Okay, but you
we
couldn't
wouldn't
factor
be
it in.
exactly
Right.
according to 2138.
And the only one to factor in on that criminal background
Would be
is
the
that
current one, right.
that
Within the
repeat
7
of that
years.
crime, not the
original crime taking
not
place.
the auto theft in 20 years ago or whatever the deal is.
So that's actually a great point because you would know about the previous crime. We have lots of cases where the crimes start in 2000 and keep on going. So you would know about it. You can't use that as a basis for denying them the license, those previous convictions. But would you want to consider the previous convictions only insofar as whether they show rehabilitation when you have a repeat offender of the same crime?
Yeah, I think that's the point, is that it's just for rehabilitation purposes. That I'm guessing if you did something 2 times or 3 times, it's more likely that you'll do it once more. And I don't know, maybe the board can seek further assurances or something from the applicant to show that they're truly rehabilitated. And it might be, oh yeah, what's different this time is they got counseling while they were in prison and they understand what they did was wrong this time and it was wrong last time, whereas before they didn't think it was wrong the first time. It's like, okay, rehabilitated.
This
Makes
would
sense
just
to me.
flag this situation. They wouldn't necessarily deny them the opportunity, correct? So,
Right. So you're now looking at there's legitimate grounds for the denial,
Right.
based on the restrictions now in AB 21.8. But even if you could deny them, should you, because whether they have been rehabilitated, and that's what you're discussing right now is under the first prong is, well, they completed their sentence without a violation. So within that, can we say that they've been rehabilitated? Well, what do we have to look at that?
I thought we
within
already
that?
said we weren't taking that first approach.
Well, you're still considering factors around that first approach, and if you don't find rehabilitation by those factors, you're going and looking at the rest of the rehabilitation factors. So basically, they're getting two bites at the apple, 2 bites at the apple. So what you've rejected is just saying, okay, they've completed, they're rehabilitated. That's it.
Good luck on the
So
first
we're just
challenge
looking
on
at
this
under
one.
the first, when you're just looking at for those applicants or licensees have completed their sentence without a violation, we're going to consider if that is enough for rehabilitation based on this set of criteria. And it's the 5 that the legal office has set forth, or whatever we come up with that's different than that, or in addition to that.
And that comment that was made illustrates part of the problem with these 5. There's certainly good terms in there, but it seems to only envision a single act or a single crime, even though it says S. So it doesn't really have options of what do you do in cases where there's more than one crime or act. And so that's some of the clarification we were seeking, is there are other options you can put in there to really assess when we're looking at more than one act or crime.
It's the same question as really the one I raised. Does that concept of multiple substantially related crimes, or successive substantially related crimes, fall under that category 1 of nature and severity?
or do we need to define it further?
I think it's fair to make that recommendation to the board, or to ask staff to come up with the legal mumbo jumbo for what would go in there, because again, it's going to be very careful language, and just like the poor pharmacy board, which looks like they were the first ones to do this work, then it becomes an example for everybody else. And so it's probably going to be pretty consistent throughout the department. If this concept, number one, is legal, like is the board allowed to consider something that is perhaps more than 7 years ago, but was otherwise substantially related for purposes of rehabilitation? I think there might be room for that, but I don't.
Yeah.
I don't know.
Just to clarify, the ones that we were talking about before were just templates. I don't know that the pharmacy board has actually moved forward on their
okay.
regs. But this might be an area where, like I said, Anahita and I are still working on maybe changing these factors. We're hoping to have an agreement between us on the legality and how hard it would be to get through regulations presented to the board for their regulations in April. This might be something where you might want to select a member to delegate the final approval of what goes to the board to 2 members or 1 member to work with us. But I don't know if anyone wants to volunteer. I'm just throwing that out there.
I
that's
volunteer
just-
Bill.
Oh.
You're the lawyer?
No, I think we should. I think.
Or you could still discuss it.
I
I'm
no,
just
I really
throwing
think
that
we
out
should
there
just
as a-
make the
Recommendation
the
of a repeat.
recommendation and
You recommend you're just delegating it to the attorneys then?
for that language, and I
Okay.
think both concepts work. The idea of multiple substantially related crimes, which is different, numerous different incidents. It could be 2, versus what I call successive or multiple of the same substantially related crime, right? So you've done insurance fraud once, and you've paid your price, and now 10 years later, you're doing insurance fraud again. And the question is, are you rehabilitated the second time,
Just because you've completed your sentence.
even though you've completed your sentence? And it's like, okay, well, we're going to weigh in that you did this once before.
Right.
And to the other point, it's like, oh, and we're going to weigh in that you also stole money from the patient's purse, and you did credit card fraud. All 3 substantially related for their own reason, and
therefore we don't find you rehabilitated.
right. It's just another example of you doing acts of dishonesty.
Right. And therefore we don't want to have you licensed or registered.
And
I'll get it
no,
one of these
and
days.
therefore, you have to prove something to show us you're rehabilitated.
Right.
But we want that addressed in your prove up.
Yeah.
But I can't I can't think of anything else where it's like, oh, how do we know if somebody's rehabilitated or not?
In the context where they've completed their
Yeah.
Right. And I don't want the criteria to be whether they bring in moral character evidence, which means a declaration or testimony by their church or civic group organization, which, when people try and get off probation early, they try and show that they're an upstanding person. You get all sorts of character type witness stuff. I don't know that that's really important to
So
be
their explanation. What about their explanation?
right. Well,
of the
they put on
crimes?
their
Right.
case, and so they have. I would think that the board would have to listen to whatever they put on, and if you do put on you bring your minister in or whatever and said, oh yeah, he's totally rehabilitated. And I'm the chair of the County Opticians Association, and he's an upstanding member, and we were excited that he's coming back to the community. It's like, yeah, you weigh that. Whatever the petitioner brings, as well as these 5 criteria. But I don't think you can't tell people they can't provide those proofs of their
Goodness.
rehabilitation. Unless you think we need to expressly say that. I would just think you have a right to.
Right. I mean, I don't know that it's something. I don't know that that's something we could mandate. I mean, you have a right to set forth your defense, and if you want that to include whether it's the optician or the dog walker, if you want it to include that material, then you should be allowed to present that within your case.
I mean, the way it's the template is that it's that doesn't change evidence if any of it rehabilitation submitted by the applicant or licensee. So that remains.
Okay,
ultimately.
Okay.
So if they haven't been rehabilitated because there hasn't been a showing of rehabilitation because of the first set of criteria, they're going to look at everything. The nature and severity of the acts, the total criminal record, the time that has
Okay, right.
lapsed.
So it's still there.
Yeah, it's all still there.
Yeah, so that's covered. It is said, interestingly, it is explicitly said. But, yeah, I just think that maybe it fits into that in the second grouping in 2.
It does.
They
yes.
talk about subsequent acts, but I'm talking about prior acts as well.
Well,
You follow?
I think if we're all on page 10, subsection B, point 2 is the total criminal record. So there's one is the nature and severity of the acts. But 2, then, this is the additional criteria that the board would look at or staff would look at in order to determine if rehabilitation has occurred.
Okay, I was looking at the previous
Yeah,
page.
Yeah.
So the previous pages.
I think they're the same because one deals with criteria for denial and one deals with criteria for discipline.
For discipline, you're saying it
It
looks
would-
at the total criminal record.
Yeah, option
The
2.
other one, it's evidence of acts or crimes committed subsequent to the act.
Yeah, that still would be a consideration, the total criminal record.
So I think that subdivision B then sets out for us additional criteria. Okay, you haven't done that. You haven't been rehabilitated simply by the completion of parole or probation. So then we would also look at the severity of those crimes, those acts, the total criminal record, the time that has elapsed since commission of the acts or crimes. So maybe
Yeah, I think
maybe
the
in
total
there-
criminal record then covers it.
Covers
and
it.
that's
But that's after there's been a determination there hasn't been rehabilitation shown based on the first category of you've completed without a violation.
which we understood that's the route that the board's taking.
Yeah, the route is that they look at that first.
Okay.
They're going to look at whether there's been rehabilitation shown on
Okay,
that
so
under
you
those
finished
criteria.
your term, and now you
finished your
You did your
term.
time. You finish your probation and parole. Now you advance to level 2.
No, are you rehabilitated based on the nature and gravity of the crime, the length of the applicable parole or probation? This is what they. Okay, you are because we've looked at. Oh, you had a long probation period where you didn't commit a violation. You know, all of those factors. We don't go to anything else. We don't have to look at all the other criteria. But if you didn't show rehabilitation, we'll then open it up to all these other factors.
So I think we need to put that repeat wordage then in that first section.
Well, not the total.
No, no.
Well, it's
Yeah.
interesting. It's interesting. So if you advance, then if you are not found rehabilitated after the first bite, then we're going to look at your whole criminal record, which is going to make it even less likely, unless that was your sole offense.
Well, I like the idea of having, the what you had mentioned before about multiple substantially related, how close in time, all of that in the first. That's why I like that, having that as part of the first.
Then it puts
Yes.
you into looking at the whole.
Yeah, I would.
crime.
Right. You get to look not at the whole record, but just at that part that's a repeat of the
No.
of substantially related crimes.
No, the way I'm understanding is, if you have those repeat, then they can take it to the next level of looking at
Yeah,
your
if
entire
they're like,
record.
oh, they might decide, okay, that we don't care that you completed that one section without a violation because
You've done it
what about
before.
there's
Right,
you've
so
done this
no,
so
you
we're
didn't
no
pass
on
that.
that.
Right.
Let's go
Right,
the
and
But
then
then
it's
you
going to
look at
be
the
even
whole
harder.
record. Yes.
For
That's what I'm
somebody
saying.
like that, it's going to be even harder.
Correct.
Yeah, I'm not against putting it multiple. Oh no, a repeat or prior.
You were using successive,
Right.
which I think sort of gets at it, but I think
Right, but it's prior offenses for the same type of substantially related.
Okay, I
Right.
don't think when you first discussed it was the same type though of substantial.
The first
was
time
the same.
it was the same.
Yeah, but that's
But if you're saying like
insurance
time
fraud,
they-
insurance
yeah,
fraud
exactly.
is what I'm
But what if it's
Getting
like
at.
insurance fraud and something kind of like insurance fraud?
right, yeah.
forgery.
Or it's
Yeah.
also financial.
Say that.
related.
Right, a financial
A financial,
understand.
right?
Right, and in that context, it's like that really is the same type of dishonesty.
Right.
And so it's like,
Have you been rehab?
yeah, so you did, some sort of bank fraud the first time, and then you took from
insurance fraud.
insurance
Yeah.
fraud. I think that
They're
that
similar.
they're the same
But how do you
same
word
type
that?
of.
Or do we leave that up to you guys and figure it out?
Same or similar.
Yeah, that might work.
Yeah, we could work on
I
it.
have faith in you guys to figure this out.
Query whether a parent paying
Oh
a
my God.
college consultant $15,000 extra to get their kid into school, which warrants a federal indictment, meaning some sort of crime or dishonesty. Should those two actresses be able to be opticians in California?
It was their first crime.
But that gets to what we were
Sure.
talking about earlier today, and it's like, oh well, it is. They are financial dishonest people. According to the federal government, they committed. They allegedly committed dishonest services fraud and dishonest service fraud through the mail. Might preclude people from practicing opticianry. Maybe that's what we want.
We want the public to be protected. Right. And so if we see that there is a history of fiscal crimes or fiscal dishonesty, we have to take that into account, I think, as to
If you
Whether or not
you
they should
think
be allowed to
if
be
you
able to
if you think that protects the public, correct?
I'm okay with Felicity Huffman being my optician.
do you want us to take a vote on
Yeah.
option one,
do you wanna
option 1, 2, and 3?
Do you want to talk about anything
web
else,
back.
or? I'm thinking maybe you could entertain a motion to present your regulations on this issue consistent with the template, with the addition that we talked about, with the caveat that Anahita and I may present to the board slightly revised other template conditions.
What would those other template?
So we don't know yet. So do you want to talk about some of the problems with these ones? That I
Yeah.
think there's two in particular.
It's mostly the lack of clarity. So the second, or maybe the third one, talks about the second one, the length of the applicable parole or probation period. This is supposed to be a factor that's being assessed as to whether this person has rehabilitated, and it's not quite clear which way that's supposed to go. How is the length relevant? It just says the length, but there's no direction on if it's more. Is it the
Is
high
it better
term,
if
the
it's
mid-
longer or shorter?
Right.
Okay.
So there really isn't direction what we're supposed to do once we determine what the length of probation is. Okay, we've determined it was 5 years.
Mm-hmm.
What does that mean as far as rehabilitation goes? There's also the extent to which the parole was shortened or lengthened and the reason for it. A lot of times we just don't have that information, and we may not have that information. If it was lengthened, I suppose theoretically there's been a violation of probation.
Mm-hmm.
And if it was shortened, we just simply may not have that info. The terms and conditions and the extent to which they bear on the applicant's rehabilitation. Another question arose that, are we talking about whether the parole terms were appropriate for the criminal conduct, because those are in sentencing laws. That's been determined by a criminal court that it's appropriate. What exactly are we assessing is appropriate? So what are we saying what are they rehabilitated from? And does that make them now fit to practice? So these conditions, my understanding is that these elements were taken from a criminal context and they're used in a criminal setting to determine possible recidivism or if probation should be extended or modified, but they don't seem to quite fit in what the board's supposed to do with these when determining whether someone is fit to practice the profession they've chosen. So we were kind of looking at guidance of how the board would or the committee would interpret some of these in the context of the profession, or give some direction.
I see folks chewing on it, so I just wanted to chime in that 2 does give me some pause, because I'm not sure how it is that staff could better determine what should be the length of parole or probation than the judge who assigned that parole or probation. And so I'm not sure that this is applicable to whether or not someone has been rehabilitated, simply because we don't have the ability to judge that. My thought would be, well, then what's the average length of parole or probation for this particular offense? And I think we're wading into something that isn't our purview at that point.
Yeah, I think it's that you raise it. It is kind of an unfair task. For a lot of misdemeanor crimes, in addition to paying a fine and whatnot, you might get some community service, and then placed on 36 months summary probation, which is just don't do anything wrong for the next 3 years and you're good. That could apply to some of the things that are substantially related as well. And so, yeah, if I may have had a case where the probation might have been 30 days. For some reason, I think maybe the judge might have been inclined to give no probation, but by giving 30 days probation, it allowed the person to get the crime expunged faster, because you can only do that after you've finished your probation. And so if there was no probation, they'd have to wait some other like maybe a full year or something. I don't know. But the idea is like, yeah, if it's short, that might not be a helper for rehabilitation, because it's like, oh, how did you 1 year and you're rehabilitated? And then some people might say, oh, they were on probation for 10 years. How awful they must be because it was 10 years. And it was like, oh, well, no, that means they've kept their nose clean for 10 years, and that might be a better indicia of rehabilitation. But whoever the decider is,
Seems like a lot
might
to
weigh
put on
those difference.
staff.
That's what I'm saying.
Yeah.
It's
And
I don't think that it's necessary by statute. I think it was an attempt to have some criteria
Right.
that otherwise, again, it's just have they been rehabilitated, considering that they finished their probation or sentence without violation. And what are we looking at for that? If we have discretion, you're telling us we have discretion, what are we looking at? So I think there's room to lessen the burden on the staff, but still come up with some other factors that deal, within that nature and gravity of the crime. And one of them that we just discussed, and maybe one is enough. I don't know. That's kind of what we kind of wanted, opening it up to you guys.
And
to
this
see.
may be a direct or indirect response to case law that is used in an administrative setting that does clearly say if you're on probation and you complete it successfully, that period that you were on probation and completed it successfully does not count as a consideration in rehabilitation, because the idea is you've got a hammer over your head, so you are motivated to comply with it. This is somewhat in direct conflict with that case law. It's essentially saying, yes, you do have to consider it. So now we're thinking, okay, if we have to consider it, what factors are important? We can't just dismiss it at this point and say, well, you were motivated to follow the law. What else would be important for us to see that you actually were more than motivated, there was actual rehabilitation occurring?
right. In the discipline context, we use the length of time since the violation, or whether substantial time has passed since the violation, and it might be. But again, just saying that doesn't tell you how to weigh it. It might be along the lines of, to the extent remoteness in time of the substantially related criminal conduct has elapsed, but the point is, then you would read that as saying, oh, if it happened a long time ago, it can be weighed in favor of this person being rehabilitated. But it would be clear from that if it happened a long time ago, it's more likely you're rehabilitated than if it was more recent. Which you have to say, instead of just saying the length of time since it happened. Because that really doesn't tell the decider whether the length of how to use that tool.
I think those were some of the, I believe, to your comment, you said, which ones would we be looking at possibly modifying? Those are the concerns that, yeah.
Yeah, I mean, having talked it through, the other four, the as you said, very vague. So maybe having you guys look at additional language might be a good move forward, along with the repeated crime element that we spoke of.
Sorry. On page 10, these are B 1 through 5 that we're talking about? Or are they okay. So nature and severity of the acts speaks for itself, right? The total
No.
Oh no.
That's
Okay,
that's phase 3.
Okay. So
So it's the top.
A,
above
1,
that.
2,
A
3,
one.
4,
Yeah.
5.
Okay, so the nature and gravity of the crimes, the length of so 2 is ambiguous, and we think my proposal, which we'll make a motion on eventually, would be for staff to punch that up to talk about um, the the length of time since the crime, and whether well, I don't know how we
mean,
say that.
does-
Maybe you can look at that discipline language about the idea of it being remote in time versus being recent.
But I mean, if you think about the crime element, haven't they served time in jail during that period of time? So there's less chance of committing
well,
that crime.
they might not have served any time in jail.
Fair.
They might just be on the street on probation, not even supervised probation.
Fair. All right.
And so it's just like, is this something that happened a long time ago? Now, in the context of like, you get my drift on that temporal scope, and then the
I
extent.
think you have more criminal prosecution experience, so we appreciate it. Did you understand what he's?
I think so. Is it the time that has lapsed since the crime was committed, or since
Probation
they
ended.
they've probation ended? Since
I
they were
think
released?
you could put both.
Okay.
Because if it's time since probation ended, then you're really golden, right? Because then you don't have that hammer issue.
Right.
But if it's in those discipline cases, the board is getting cases that the so-called unprofessional conduct happened over 3 years ago, and the person has been practicing fine for 3 years, and then all of a sudden they're not fit to have their license, and it gets revoked and reinstated, only because the insurance company that they defrauded finally got paid back in full, and once they're paid back in full, then they complain to the Board of Optometry. But they have no concerns about the professionalness of that practitioner as long as they're requiring them to pay off how much they defrauded them out of. But the point is, it could be many years before we actually find out that the bad thing happened, and it's like, oh, I almost forgot that happened. It was so long ago. Of course I'm rehabilitated. And then shortened or lengthened. And it's the first part of the test talks about successful completion of probation, right? So that shortening and lengthening, that's where that discussion would come up. If they got lengthened, it's because they didn't comply the first time in it. So we would learn about it there, we think.
I think part of that problem was you wouldn't know the reasons for it necessarily unless there was a lot of investigation
A lot
up
of
front.
investigation, yeah, that we would have to move that to Department of Investigation to find out why to find out
What-
even if it had been extended.
Whether it had been extended, I mean, I think if it's been extended, there's been a violation of probation, which wouldn't even put that person into
Right.
this category.
Right.
So it doesn't really make too much sense. And whether it's been shortened, I don't know that that's readily available information unless the applicant is able just to provide that to us, and
Well,
we can
is that-
consider it.
How is this information collected in the first place?
Right now, it's not.
Right.
This is
so would it?
Oh, you mean where would it come from?
Right. So wouldn't this be coming from the applicant saying, "Oh yeah, I did serve jail time. I am rehabilitated here." So he could provide these things, this information, and then it's up to staff to refute it or.
3 is consumed by 5.
Yeah. It's the
So
same.
we can delete 3.
Yeah. But that still goes,
It's the
I
same,
mean, the
yeah.
question. For
But
fines.
we're basically talking about information that's provided by the applicant at that point, right?
Right. There's also a question of, is this putting the onus on the board to go out and obtain that
Right.
information? Or are we saying, if the applicant provides us with these information, we're going to assess it? Now, the applicants, to obtain this information, we've got applicants that have 10 convictions. That may be very burdensome on them and costly to obtain all those records to provide to the board. And in contrast to what information does that really provide the board in determining whether they're rehabilitated or not? So it doesn't seem like a very helpful thing to consider, whether it's been shortened, lengthened, reason for the modification, because at the end of the day, what we know is they completed probation, and without violation is why they're in this category. So that's really all we're considering, unless there might be something in there.
Does it help to say above this, in making this determination, the board shall consider evidence supporting or refuting rehabilitation related to the following criteria, or something along those lines?
Is your intent to give it more discretion for the?
Well, to make clear that, like, on some of these, to the extent to which terms and conditions of parole or probation were modified and the reasons for the modification,
If they're
that could
available?
help.
Okay.
That could help the person get rehabilitation finding, but it could also be presented by the victims' families and hurt their chances of being determined to be rehabilitated. But again, right now, it gets to that point of, it just says, here, the criteria is there. It doesn't say how to use it. But for all
Right.
of them to just, like, to kind of treat all of these things, like any information you have on these that's aggravating or mitigating towards the finding of rehabilitatedness.
Well, I know the intent wasn't to put the burden on the applicant or licensee. It was that staff would be doing the investigation and trying to get this information. So it comes from the official source, which I don't know exactly what that would be. But that's why we're concerned
Right,
about
but you
some
can
of these. And then-
imagine probation being modified because this violent person was gotten 3 fights in prison versus being this this unfortunate kid who was in the wrong place at the wrong time, has since been a troop leader and active in the church and an outstanding community person. And then it's like, well, a judge might then say, you know what, we're going to modify the probation because we know you're trying to get a real estate, or in this case, registration. Because people use that in the criminal court. People would use this all the time. It's like, oh, can we get a deferred entry of judgment, not a finding of, we're not going to enter a plea of no contest on this misdemeanor crime. It's like, we want to become my client wants to become a real estate agent or whatever, and this might jeopardize their ability to get a license. I never knew if it was true or not, because it's really for the judge's decision, but I didn't know the licensing process. But people would raise that all the time, and I can imagine now seeing these kind of things why you would say that. You don't want, like, yeah, I'll just let me keep my nose clean for 3 years, and if I don't do anything wrong, everybody dismisses the charges because it's not the biggest crime of the century, and we can prove rehabilitation to you, judge, in 3 years. And then, okay. And then prosecutor's happy with it. The charges are dismissed. But there may be good reasons for whoever reduced the length of probation.
Just going back to the intent of the law in to decrease barriers to entry, and they definitely wanted there to be, they still gave the board discretion, but consideration of that factor alone from the other factors that they've finished without a violation. And again, back to Ms. Crawford's point, it's almost like they didn't like that case law that said that doesn't mean anything really, because
Oh, I
a lot of
see.
time when
Yeah.
they're in prison and they have to, they're going to get in trouble if they violate. So I don't think you want to add factors that necessarily increase the barrier under that, but you got to be careful how again it has to be consistent with the law.
Was the suggestion to add a modifier to 5 so that it would say to the extent to which the terms or conditions of parole or probation were modified, the reasons for the modification, and the extent to which it supports or
Yeah, I think it could be put
Rehabilitation.
there. My original thought was, could that be put in the sentence above items 1 through 5 and have that apply to all of these things?
To the
To
extent
consider the extent these
supports the
support
showing of rehabilitation.
or are against or refute a finding of rehabilitation, consider these following criteria. That just is another way of saying for all of these things they could weigh both positively or negatively.
I think it's vague enough right now that it could go either way.
Yeah,
Making this the
that
board
might
shall
be-
consider.
That's true.
But-
I mean, what we originally stated as kind of part of the problem of these things, that the vagueness. Allows you to consider them either way.
it may also be somewhat repetitive. 4 and 5 kind of seem like the same analysis. You're looking at the terms and conditions of parole and probation, and you're really looking at how those terms have rehabilitated this person, but again, for what purpose? That they're rehabilitated from their criminal conduct, or they're rehabilitated where the concerns you would have from that wouldn't translate over into their profession. I think it just needs to be, the idea is there that we're looking at terms, we're breaking it down to see how it relates to the profession. We just need to maybe flesh it out a little bit to make it a little more applicable to the licensing environment.
Can you try to? Oh, is there an example? I'm just trying to, like in the context of optometrists or opticians, what type of term or condition would
Well,
relate to
I
the
think
profession?
if you do have, let's say you have an optometrist or an optician that is convicted of a financial crime, and there may be situations where probation terms would include some kind of ethical work, some kind of courses, classes, and some people whose probation terms wouldn't include that. So in looking at those terms, the one who did take the courses and classes, you might say, well, that person is more rehabilitated for this profession than the one who's simply rehabilitated because they completed their probation.
That's helpful. Yeah.
Right, because everybody's going to get their first condition is probably going to be number 1, obey all laws. So you can't speed. You can't. So you can imagine some of the young celebrity cases where they might be a DUI or something, and it's like, yeah, if you threw eggs on somebody's car, that's vandalism, and that violates your probation. In the DUI case. And so there you can get picked up immediately, and you now you get punished under the first crime. And so, but some people, condition might be like if you shoplift from somewhere, it would be probably a pretty routine condition to stay 100 feet away from that location. It's like, yeah, you can't go back there. And so it can be it's not a otherwise violation of the law to go walk into the grocery store you stole something from. But by showing up there, you've now violated your terms of probation, and they'll punish you under that. And then you'll have like the coursework. So again, like DUI, people have to attend certain AA meetings or classes, or people get anger management, training. But the idea of, if you think about towards our towards optometry's violations, we make people do the continuing education and that sort of thing that actually is probably going to be a helpful factor to them, taking the ethics class or undoing the wrong that was the unprofessional conduct.
So I think 4 is good as is what I'm hearing, kind of. Maybe just fleshing it out a little bit about what the, bearing on the register.
It could be that it's 1, 2, and 4 is really all we need.
And 4 maybe might be clearer if instead of they bear on the applicant's rehabilitation, it could say that something more about the fitness to practice their profession, so that it's clear what the rehabilitation is for.
No, I want to go back. So we want to change 2, or did we want to strike 2, where it is that staff would be required to obtain additional documents to determine. Oh yes, I'm sorry.
That staff would have to understand the maybe average length of parole or probation for a like offense. So you said that maybe all we need is 1, 2, and 4.
Yeah, I was thinking of 2 in terms of that temporal scope, the recency versus remoteness of the
I thought,
of the crime and of probation.
But I'm reading 2, the length of the applicable parole. I'm just reading that as the length of that individual's parole, not like paroles for like crimes.
Right.
But he's modifying it.
So the idea would be you did something bad and you've been on probation or parole for 10 years, that's somehow relevant. And then the hard part is, well, what's better for that applicant, whether they were on probation for 10 years or whether they were on probation for 1 year? Because being on probation for 1 year means you just did the bad thing maybe 12 months ago. And so instead, I think the more relevant inquiry is the length of time since the incident and the completion of probation, as opposed to the probation itself.
And then one we're also putting in the repeat element, correct? And then you're saying strike out 3, strike out 5, and then 4 maintain.
Because 3 and 5 are related to the terms
Right.
of
3,
the
4, and
terms
5
or
are
conditions.
basically you can work them all together.
By keeping 4, the terms and conditions
Yeah.
of parole or probation. Okay. To which they bear on the license or rehabilitation.
And then
Okay.
was there a suggestion on adding to 4?
I think I had said to add to the extent which they bear on the applicant's rehabilitation and fitness to practice the profession.
Right.
Yeah.
Thank you.
So is that the motion we want to move forward in making that?
I'll second that.
I'll have to watch the, the video, but I think, are we good? I think so. Yeah. Thank you, guys. That was helpful.
More public comment.
You know what I do actually? One point I was curious about: the nature and gravity of the crimes. Does that include the circumstances surrounding the crime?
I think
Okay.
that's the nature.
Okay. Then I'm good.
But it doesn't hurt. But as you guys go back and look at this, I think there's it doesn't hurt to say the circumstances, comma, nature, and gravity of the crimes.
Because that could bring into effect whether it was somebody who committed it when they were very young or wrong
in
place,
the
wrong
in
time.
the exam room versus the nature of a crime. It's a financial crime or a fraud related crime or a violence crime. Circumstances covers the whole story. So I think it's probably not it's probably a good belt and suspenders to add that.
Okay, so can you amend your motion to say that with those edits that can be taken?
Yeah.
Or do you, yeah.
Yeah, I offer an amendment to the motion to capture the discussion we just had, which is essentially to include the circumstances as well as nature and gravity of the crimes in number 1.
And then to take those edits as otherwise consistent with the template suggestions to the board's meeting in April,
Yes.
as the DOC's recommendation.
I'll second.
I was the second.
Oh.
That's for
your
the amendment.
No,
Yes,
amendment. I'm
that's it.
seconding.
Well, then it's a friendly.
And yeah, any more discussion? Any more discussion?
I'll start with Con,
Aye.
Bill,
Aye.
Anna,
Aye.
Adam,
Aye.
and I vote aye. Do we have more on agenda item number 8?
No.
We're good? Okay.
Thank you.
You're welcome. So are we going to want to go back up to agenda item number 7? Are we ready to do that, or?
We gave you a memo that just summarizes the changes. Most of those changes were heavily discussed at the last meeting, and we gave you a clean copy, but it is still on hold because we have not received official word and I think a legal memorandum from the department about the uniform standards. Because we're also working on 2138, there might be further changes. The Board of Optometry's moved their kind of deadline for their disciplinary guidelines into the fall. So we just, unless you have questions about it, it was just kind of wrapping it up from last meeting.
We as staff just knew that the conversation was a little convoluted with all the redlining and then the also changing, so we wanted to bring it back to you with a clean copy and let us know if there was any discussion that needed to be had now that it was clearer sort of seeing what we determined during our conversation last committee meeting.
But it's not the last version.
So that brings us to agenda item number 9, right? Yes, discussion and possible action regarding committee priorities through the next strategic planning process.
Thank you. I wanted to make sure, and we have copies available for the public, that the board had in front of, the committee had in front of them, the strategic plan goals. Were those
I
added?
also added it just this morning
Oh,
to
okay.
your cloud drive. So you should see the strategic plan goals in your cloud drive. But they are also shared.
If anyone wants a printed copy or anyone in the, yeah. Yeah, no, I definitely do. That's all of the strategic objectives. It is 3 pages, yes. All right. Excellent. Okay, so we're bringing this back to you, in great consideration because most of these were discussed and prioritized before the staff that you have before you were in their current roles. We wanted to give each committee an opportunity to look through what they had prioritized in prior discussions and give us further indications of what they see as, the things that are most pressing or most needed. We have also, in conversations, both during committee meetings, our last committee meetings, and in conversations with legal counsel and with individual members, have raised other issues that might be of consideration and prioritized. And so we wanted to bring to everyone an opportunity to give us some direction on how they felt that should go. So we'll begin with, there we go. So we have in August 2017, we the committee was given a list of priorities for the board to review, including outreach, payment methodology, education requirements, licensing pathways and applications, updating terminology. I'm kind of thinking I'll run through the list and then we'll go back and discuss them further. Scope of licensure in private settings, valid business relationships, decoupling and mobility, required continued education, harmonizing the RDO program and optometry statutes, cite and fine authority through regulation, and out-of-state or electronic commerce. So I think within the outreach, first, we have as an attachment the 2017 outreach plan or communication plan that was prepared with the Public Relations Office of DCA that looks at objectives for helping the potential licensing and community, registrant community, understand the need for registration and providing that communication to both those within training programs and those who are currently working in situations where they are either overseen by a registered dispensing optician or overseen by an optometrist or ophthalmologist. So they'll see there's that outreach plan there. Payment methodology, I believe, was the ability to
Take credit card, I believe, on the website, right? Or checks. It was one of those, yeah.
So this was in regards to, so there's a stopgap between if you pay by check, you can only pay online if you have a credit card. So some businesses that do not have a credit card attached to their business, they only set up a checking account. They cannot immediately pay for the funds. So what they were doing is, they weren't until quite recently submitting their applications online. However, I worked with, and this was the particular case that I'm talking about was Luxottica. I worked with the contacts that we have there to explain to them that they can submit their application in advance and send a check once they have the application number. So they're aware of that system, but it's still there's that window where there can be confusion, and they're still sending in paper. There's still so it's the ability for Breeze to enable payment methods for checks, so the account and routing number.
Okay, so our workaround was essentially to have folks apply online, obtain an application number, and then send in a check with that application number on the check. We were letting folks know that it wasn't necessary to submit a written application because we were trying to get away from written applications. And so that they could do the two separate. You could do online with your application, but you could still submit payment with the application number by check.
Correct.
Okay.
Yeah.
All right. do we feel as though that's a fix for?
Yeah, I think if I recall that was like a low hanging fruit for industry that we tried to get taken care of as soon as we could, which I think staff did pretty quickly. I actually, sorry, I have a question. So we had the conversations with the ABO testing, and they would put in a note for all California residents, or so they would know you're not done with to get your Thank you. Okay.
Versus a certification.
Right, from them. So there was the case was happening that people would take the test and think that they were registered at that point. Now ABO puts in the note saying, "Oh, you're not done yet. You have to still apply with the state." Do we know how many more? Has there been an influx since that went into effect? Did we see progress from that outreach, basically?
So yeah, there was a bit of progress. What's more causing like the issues now is employers misinforming their employees, which we're also trying to fix currently. So right now I'm trying to contact with all our major employers like Luxottica, Costco, and make sure to give them notices like, hey, please send a memo to all your managers that this is what actually needs to be done. Because the most common one I get is people calling in, they're like, oh, my manager told me to do this.
So what they're doing is they're doing the registered dispensing optician application instead of the spectacle or contact lens application.
Right.
So as far as the ABO implementation, though, have we seen an increase of folks then realizing once they've got their ABO scores that they need to come to us for?
We get I get calls occasionally going, oh, I got my ABO and I was told by them to contact the state or and apply for our registration. So that's been fixed. We just came up with a new problem in its place.
Okay.
All right.
Okay. So the next was education requirements, testing, licensing pathways, and applications. Ruby, do you want to speak to this? I mean, this has kind of been a churn for us behind the scenes, but having an opportunity for folks to discuss here, kind of some of your thoughts on what's going on within the industry and what we sort of want to take a look at.
Oh, okay. So we are already with the occupational analysis looking at what's going on, what's going to help us. We don't have any established education requirements. And we are looking at the testing, whether it's going to apply to what is being practiced. And we are not licensed, but we're considered registered. And so this is still something we need to work on. It's probably something that will take some discussion. We can look at what other states are doing in this regards. There's a lot of just comments overall saying, taking just the exam, both of them, it's just not enough. The industry changes, but there's also some learning gaps in between. Just taking a test, if you do really well on, doesn't really guarantee that the consumer is going to be protected by what you're practicing, is some of what is being voiced. So there's a lot of venues for educational requirements. It's not just one venue, I think. I don't know how the committee feels about it.
So I think in the context of this discussion, what I'm hearing is that maybe it would be a task to staff to do research on the education requirements of other states. That might be one way in which to.
I don't have the best memory, but I thought
We
the
did do
DOC
through
went
this,
through this already and before you started.
Yeah.
So, and I can't remember when exactly.
And there was a product that was brought committee. Okay.
Yes.
There was an outline of it, and we did have discussion on it. As I recall, it was more about looking to see whether continuing education
Yes.
should be. But what we're talking about here, it could be beyond education requirements, could be something more than just the continuing education classes. Is what I'm.
You mean initial
Yes.
requirements, and I don't remember if I thought you discussed that too.
Yeah.
two charts by the states.
Mm-hmm.
One might have been, it might not have been even education requirements. It might have just been registration or licensing requirements,
Right.
and then a separate thing on continuing education. But I think there's
Yeah.
a work product on that.
Okay.
I'd
So-
probably have it.
In taking that discussion has occurred. There was a look at that work product.
Mm-hmm.
What were the directives from committee in order to move forward with that information, or was it simply great to know? We don't have a recommendation or a delegation to staff to work on additional information or promulgate regulations or or potential bill language or.
Trying to remember what
I think it was behind the disciplinary guidelines and all the other stuff,
I-
and we'll get to that sort of thing.
And
Yeah.
we were a smaller committee. What we did come up with that it was too expensive to require opticians to do continuing education. We were being compared to court reporters, who I know for sure it's expensive to keep their continuing education, and perhaps staff. So we talked about that, but the education requirements, if you look at the other states, has to do with how many hours of practice they need to do, whether they need to go to some sort of college to finish a degree. They do have certain requirements that are more than what California has. No requirements at all. Okay, so we never really discussed that, but we really did get into the continuing ed and just felt that because for reporters it was expensive for them, that it might be expensive for us. And it may be, if it starts to be mandatory, that could get expensive if they see that as a possibility too. I don't know.
I think there was also, if I recall, Jessica had sent a memo from the governor about continuing education and that being a detriment to our registrants because it would cause more issues and we weren't supposed to be putting more issues on our registrants per se, more expense. I believe that.
Yes,
right?
it was a veto message on
Right.
somebody who did, because continuing education would
Correct.
take legislation.
Right.
And somebody tried it for another board, and the governor vetoed it, as I think it had happened previously for other boards.
To be fair, we have a new governor.
Right. But that's the.
That was the case.
Didn't they throw it back to the employers? That's what I recalled. Because they said it should be based on the employer and
That
how they
sounds right.
choose to do the training. And
For the, I also remember industry organizations.
Right.
Yeah, that was the governor's philosophy.
Between the
Was that
seven of us,
don't
we have
need the
one
law.
brain.
This is something industry should handle in-house.
Right.
And that's particularly continuing education.
Continuing education.
So
Correct.
initial education.
There was nothing. We never tackled that. I don't believe.
Okay. And that was not included in the comparisons of by states.
No, it was. I think.
Okay.
Yeah, it was. We have work product on
I'm
that
happy to
stuff.
go through
Yeah.
my emails and find and past materials and help you with that.
So then part of this is I'm trying to sort of figure
Figure
out
out
what's
right.
the next step for
Right.
these things, and then give you guys an opportunity to say that's the next step, but we want you to look at this other item before going to that next step
Right.
on this. So I'm trying to just sort of figure out what we would want to do next. Maybe bring that work product of educational comparisons back to the board
Mm-hmm.
for an additional review and discussion.
So
Or I'm sorry, the committee. Pardon me.
Yeah, or even just waiting for the occupational analysis for us to even figure out what we're regulating before
Right.
we even say what they're required to
I think that's fair.
continue education.
Okay,
on.
great.
So I think that would be a great first step for me, just to start with the occupational analysis, go
See
from
the
there,
data,
and because at some, we'll go back to the whole story of like, I don't want to do continuing education. I'm just going to work under someone else's license. So I think, tackling that first would make more sense before.
Great.
And in the scheme of things, I think it's laid out like this because it was like, first and foremost, we have to do outreach so that everybody knows they have to register with us because people don't even know that they need to do that.
Mm-hmm.
Then we need to get our registration in order and how to get people to be able to register online and get that all squared away. And then we can start looking at the educational requirements and so forth.
Yeah.
And so I think it flows from there. But the outreach was number one because it was like we didn't really had a grasp on how many or who or that sort of thing. So first, everybody needs to know they need to register with us, and then we need to have that back end of the office operating, and then these are the neck, and then we have to do disciplinary guidelines, and then
We can
these
tackle.
are like the value added.
And then about licensing, was there ever any sort of direction for us to understand what's the difference between a licensing pathway compared to a registration pathway that we have? And is that something that we just want to have information-wise?
So, I would just like to mention really quickly that, like, statutorily, the label registration and license, in the regulations, it says that those terms are synonymous.
It's actually Business and Professions Code.
Yeah.
If
Yes.
Mina wants to speak to.
So I don't,
That's good.
I think there was a discussion, though, to call it a license instead, but I think that that's just a style preference. Legally, it's you're being regulated, and it's permission, whether you call it permission by license or permission by registration. But if there's concerns about the terminology, then you might want to look to change that in the statute. From concerns from not legally, but for some reason it's causing
Stylistic.
confusion or
Oh.
something like that.
I mean, we're the only state I know of that uses registration. Because every state I've ever worked in has always been a licensed state. So this is the first time I've ever encountered a registration title or process.
Have you ever heard, though, the other states, and I know we're California, I'm not going to concentrate so much on the other states, but have you ever, I don't know if they've commented, you're really not a licensed state, have you ever heard that comment from them?
For California,
Yeah, do they say that? And what is the criteria they're saying that on the basis of what?
I think so. Like, a license is usually like, there's usually like a state exam that's attached to that. You have a state exam, you have continuing education requirements. And then that's more like what I'm familiar with the licensing process is you always have a state administered exam, and then continuing education that it needs to be monitored by the state. The state monitors your education. They also finalize with like a practical exam.
So it is a little different than what we
Little,
do
yeah.
here. So
Yeah, but it's also a lot more money to do. So I know some
Right.
states are a lot of states are, or some states are stepping away from the like practical exam. I mean, I'm sure you're going to save a lot of money by not having to monitor an exam, offer an exam. So
So, I mean, it's great it's already, that we know it's registration, license, is the same. It's just the practice seems to be a little bit different.
We're in no way, by using the term registration, I think that it gives us the sort of, we recognize that there may be things that we might want to implement within our program later on that will be more in line with other states and what they consider licensure, regardless of what Business and Professions Code, says between the different differentiation of the terms. That we recognize that our program could grow, might grow, and we're doing the research in order to do that.
Me? For me, I think going through this prioritization as a public member, the scope of licensure and our shadow, licensees that we don't actually regulate. For me, it seems like how long have we been doing this? Year and a half? That seems at this point to be like the next thing that we really have to tackle. And getting them either underneath us or figure out a way to, how do we work with that, with those people who aren't licensed and yet are doing the same job
think-
that
yeah, one way to look at it is like a licensed state will actually define who can call themselves an optician, what are the tasks associated with that title, which I think we kind of miss that, where we don't, we can have a registered optician, but like who can own that title and what tasks legally fall under that title. And that's typically in a licensed state as well.
to my understanding, and this is more of an enforcement thing, we have enforced the use of optician in practices where that person is not registered, specifically registered with the board. So we have had optometrists say that they have opticians where they are certified with the ABO NCLE, but they're not registered with the board, and that term optician is
An enforceable title.
Still protected.
Right. All right.
I'm curious how it's protected. I'm just curious. So let's just say I'm not registered, but I am working under the doctor's license. How does the board have any say in if I did something if I'm not registered?
So the term optician is protected. Your behavior, depending on if you're not licensed and you're working under an optometrist, the optometrist is then responsible. And so then I would assume that because we have authority, and again, way out of my scope, I've never worked in enforcement, but we could then pursue action against the optometrist for.
So I think it comes down to essentially if we have a complaint against an optometrist, if a client goes to or patient goes to an optometrist's office and has an issue with the service given, and has an issue with the staff members who helped in providing the service, and they were presented as opticians, then we have an opportunity to go in and take a look at whether or not those folks are actually registered opticians or simply working underneath the license of the optometrist, and then discipline against the optometrist, right, for allowing folks to use that term even though they are not individually registered or licensed with the state.
Well, I don't know. I haven't looked. I mean, I'd have to look up the law on that. I know you can't use the term optometrist without, being an optometrist. I don't know about, because they're exempt if they are under direct supervision. I don't know if there's a specific provision in the law that says that limits their ability to say that they do this type of work, optician work, because that's an exemption from the law.
So, in private practice, I know this for a fact. They do use the term optician. You can go through job boards and you can see they still look for opticians, and they aren't registered.
Right, and I'm saying I don't know that.
Yeah.
I don't know about the case you're talking about. Maybe they weren't working for an optician; they were calling themselves an optometrist. But without doing some research, I wouldn't just presume that we're saying that that's illegal right now.
Yeah. It would be great if we had just more research. So that
I'm happy to look at it.
yeah, that would be great because it would probably not resolve, but get us into understanding the scope of practice. If we had that all before us, because I'm sure we can come up with a lot of examples, but having the research first would be great.
What would be the path to get the people working under private practice under our jurisdiction? Legislation, I'm assuming?
Legislative change, yes. So you might want to, again, start with the history of why they were exempt.
Do we know that history?
Not
But
off the top of my
like,
head.
is this something that we can just take the temperature of the Board of Optometry on to see if they want to go down this path? Because like, this would be a huge undertaking culminating in legislation. We're essentially alleging that there's this totally flawed system in the state with respect to these folks. Now, there might be good reasons why it's not flawed, because there is a doctor of optometry present overseeing their work, and that's kind of more oversight than we have now. But if they don't want to, if they're not interested in entertaining that discussion,
Then it's moot.
then it's our staff time is better spent doing something else. If they say, yeah, look into it and give us a report, then we'll be like, all right, we're going to make a difference.
Okay. So I think then what we're saying is that the April 5th meeting will include the report during which the board can take action on reports as well. And so to me, I think we've got two questions at this point, right? That we want to sort of take a temperature take from the board to say that out of our committee meeting, these two things bubble up as issues which really are just the same thing. Now that I'm thinking about what we were essentially, right, the shadow when else it came up earlier, to understand, that there's this perception that we have, and I think it is going back to, I think there should be some staff time in understanding the history of the exemptions, and I think that there should be some staff time into possibly understanding what the scope of this could possibly be. What are our numbers of registered opticians versus where practice is outlawed without a specific registration? What are other states' numbers in order to show maybe possibly, of course our economy is larger, we've got more people, but if we're seeing a disparity in numbers, that might also say that there's this population that's shadow out participating, and that we are asking for the board to give us some recommendation on whether or not time for this committee, time from staff, should be spent further investigating this in order to possibly bring back to them some sort of recommendations in order to move forward.
Sorry. How does this work in other states? In terms of, does private practice, are those optician assistants licensed as well, or is it dependent on the state?
It goes down to like they're under a doctor's license.
Okay. So it's the same thing.
No, I have an example. I've done a lot of traveling, talked to a lot of opticians in other states. Now, if you were like, for example, going to New York, believe it or not, everyone working under the doctor must be licensed. They've gotten to the point that if the doctor does not employ a licensed optician there, they have shut down the doctor's office. There's been experiences like that. So in other states, there are some strict regulations that they must follow.
Okay.
And then again, I don't know about asking. It's good to get a temperature. What is it the board would like us to look at? Do you think it would be helpful? And hopefully, I don't know, by April, we'd have the results of the occupation analysis. Say, look, this is what's going on. In consideration of that too, would it help support that?
I think that, having gone through the second round of this committee, this is the issue that keeps bubbling up. And so I think that even before the occupational analysis comes in, I think it's important that the board understand that the committee is continuing to talk about this issue, and to present to them, to start thinking about it. And, when we have the information from the occupational analysis, that this committee is concerned about a potential, shadow industry of opticians participating under or practicing under optometrists, and how we begin to understand the scope of that sort of practice, and how that might differ, and that it's something that we, once having the occupational analysis research information, we will want them to consider. I think that there's something to be said to not waiting until the occupational analysis, that there is something to be said about bringing this to them as something to, at least sort of chew on and discuss and give us some feedback on before we, get to the fall when we've got full report.
Yeah, I mean, it seems like the natural, not knowing any of the history, it seems like because the opticians under the optometrists were guided by the Board of Optometry, they had free license, as opposed to dispensing opticians who were under the medical board had, medical board had their own thing going on. So it seems like that's why, at least logically to me, they're separated. Because the Board of Optometry was kind of licensed or having oversight over their own selves, right? And now the opticians are over there, but they're doing the same job, ish.
Well, it boils down to the fact that we are working on disciplinary guidelines, and we spent half the day today talking about rehabilitation and substantially related crimes, which for our registrants can become immediately irrelevant because the person that we say is unworthy of a registration can go and do similar work under an optometrist with no conditions of probation
No regulation.
and
Yeah. No oversight.
it puts into question all of the other work we're doing
Right.
when the potential regulee can just pick up their ball and go home.
And that has come up.
And actually, no one's court, right?
Right.
They're just walking away.
Under the doctor's license.
Right.
And the answer might be, well, you want to know what? The consumers are way better off with an optometric assistant working under an optometrist who's there every day, who's always between 12 and 40 feet away from them, and is keeping a closer eye on them than any optician who's on probation. I don't know if that's true or not, but that might be what the answer is.
But then I think it is whether or not we really do have the authority to make the optometrist license, to hold the optometrist license accountable for the acts of those optometric assistants who are underneath them. So then it might be a matter of looking at, okay, well, that is good for the practice, it's good for oversight, but we need to then know that optometrists need to then know that they are responsible for that and will be held accountable for the practice of that optometric assistant underneath them.
Right, but it's interesting that hygienists, dental hygienists, are still licensed, even though they're sitting underneath a doctor. That nurses are still licensed, even though they're doing work underneath the doctor. I guess some the anesthesiologist is a doctor, but an anesthesiologist's assistant could be doing the work. Oh yeah, they're supervised by a doctor, but you want to know what? They're all still licensed or registered.
So I think this discussion is under 9 because you were emphasizing that is a high priority
Yes.
for
Yes.
you. So, but I wouldn't go further into the policy of it because it's not agendized. But I think that point was well taken in that you need to know how the board feels, and so that you can make that your priority.
Okay. The remaining items on the as a part of the strategic plan were the harmonizing of the RDO program and the optometry statutes, and that came up a couple times today as we were discussing the disciplinary guidelines. The fact that the optometry has its own separate practice act, and that the RDO practice act still remains in the section for the medical board and for physicians. So this would be if we feel that there needs to be some sort of coming together of those two practice acts statutes on the professions that we regulate.
I mean, I don't see why we wouldn't, other than it takes legislation.
Yes.
I think we've presented. I remember combining them and presenting it, I believe, to the board. I don't know if it was presented to the DOC committee, but it's already been drafted. I mean, the combining, not the legislation.
Right.
But
But it has not been adopted as the board as a priority for their current
Right.
legislative package. So I think it would be, deciding whether or not that's something that rises to our bringing back to the board to say, this is one of the higher priorities, and so we are asking you to take a look at this again and decide if it can be seen in a legislative package in the near future, whether that's 2020 or 2021.
I don't think it's affecting consumer protection in any way. From from a legal perspective, the laws still exist. They're just
They're
not
just in different places.
in different
Together.
places.
I would say the legislation to get optometry assistants underneath the DOC would be a higher priority for me as a committee member, should the board deem that necessary.
Well, it's even narrower. It's, in my mind, it's optometric assistants who are practicing opticianry. There's some, like, as I think about experiences, there are some tests where the assistant just puts you in the chair and you put your chin in the thing and they just turn the machine on and you do your thing. And that person might also be the one doing the billing when you leave the office. They're not practicing opticianry, and I don't know that they need to be regulated. But in terms of our
by us at least.
Right. In terms of our scope, I'm concerned about the optometric assistants who are doing opticianry or the work of a dispensing optician or contact lens dispenser, or not
Dispensing contact lens
a
and-
lens dispenser or contact.
A spectacle
You know,
lens
glasses.
or contact lens
I
dispenser.
like
Yes.
that in the
The
in
thing
the
you wear on the
frequently asked
head?
questions
Yeah.
or whatever the public thing was, you put glasses. It was like, thank you, finally somebody.
Well, I know
spoke
that
English.
in private practice, because we keep going back and forth about all of this and the scope and whatnot. Contact lens dispensers, optometric assistants do their work. They also do the optician's work. And, we had a situation at one of the offices too, who kind of like everything we've talked about, he came from another state. He committed crimes, and he worked under a doctor's office. He actually was wanted for a felony, and he jumped all the way from the Bay Area all the way up to Northern California, and he was finally caught in November. But because he wasn't registered, we didn't know. No one knew anything beyond what the doctor's background checks entail. And so those are the risks that you kind of have to think about, because that person has the patient's information, has the date of birth, the social security number. You have everything pretty much, that's HIPAA. And you have to entrust that they are licensed or registered, things like that. But it's kind of interesting just to see, we're doing the same type of work, and kind of like what you had mentioned about nurses being registered nurses or certified nurses, assistant, but we don't have that in optometry. And I've spoken with many optometrists who they're wondering why there's less experienced people nowadays. And it's mainly because, when we're looking at the education, but we're also looking at the fact that they're not employing registered spectacle lens dispensers or contact lens dispensers who would be regulated under the board. And that would protect the doctors too. And I think if they kind of move towards the future, they can see that it's only going to help their practice in the long run and their patients, and make consumers feel more protected.
And I mean, I think it says the committee shall be responsible for 4 things. I think the first one is recommending registration standards and criteria for the registration, which I think you're doing with your occupational analysis.
They're probably grouped conceptually
Right,
where
exactly.
for similar concepts, and
We should probably just add it as an ongoing agenda item. And then each meeting will be a separate conceptual section.
Would it be, I think that there is that need for a breakout, but does it make sense to also take next meeting and really just dig into them, look at them, sort of, what does this mean here? How does this mean this? So that we all kind of have a better general understanding, and then coming back to those conceptual chunks to sort of like, okay, we identified here that this wording doesn't seem to, clarify this or that. Let's really dig into what it is we want to see in this conceptual.
I mean, maybe at the next meeting, it just be an overview of this is what are the categories.
Mm-hmm.
And if, feedback on, okay, from industry and everybody, what is priority to look at in those different categories of regulations. So that's just an idea.
Okay. And so then that incorporates 9, the cite and fine authority that we continue as we're going through enforcement cases. We have no cite and fine authority. So there is essentially sending a letter of education or suspending or revoking your license. And there's no middle ground for us to communicate to a registrant the seriousness of other acts that will, on second offense, bring us to a point of revocation of license. So I think that will bring us. We'll have that discussion further as we're going through the regs. And then it's just the out-of-state and electronic commerce, and I'm guessing that this is the dispensing of contacts
Spectacle lenses online.
online. Yeah. I think it's contacts.
We already do contacts. We do not do online dispensing for spectacles. Like we do 1-800 contacts. We already do that, but we don't do any for frames that you can buy online. Unless they're already an RDO inside California. If they're shipping from outside of California, we don't regulate any of them. But if they're inside of California, then they're just an RDO.
But then what is the distinction then for those that are non-resident contact lens sellers?
So those specifically, their headquarters are outside of the state, and they don't have like a warehouse inside the state of California with an address. So they're shipping from like Arizona into California to customers. Does that make sense, or am I not clear?
No, that makes sense. I'm trying to find then the segment that we need to address.
So currently, there's no regulation that allows for companies that are outside the state of California to ship spectacles into consumers in the state of California. However, there is a want by industry, probably a want by consumers, and it might already be happening. So there is the probably need for regulation there.
What do you mean by it's probably already happening?
Well, we know that Zenny is a company that's in California
Okay.
that's distributing this way, but they have a headquarters in. So it's just a matter of maybe looking at companies that are outside that are looking to distribute in, and seeing if that's something that we will need to regulate.
Okay.
But just as a side note, non-resident contact lens sellers are our smallest population at 30 total licenses. Okay.
So we already allow it for contacts with the registration, and then are we going to address the online sales
Of spectacles.
of glasses?
Right.
And I think that would be legislation.
I say it's 9 or 10 on the list.
You mean where it is now?
Thank you. Thank you.
That was just a fact and not opinion.
Thank you. I appreciate the committee going through this discussion. I wanted to make sure that the bubble that I'd heard last committee was what we addressed first. And so I think for us, it's let's all get more familiar with the regs. Then let's dig into what we feel like, we need to look at. Shadow population. Staff is asking to look at cite and fine authority. We'll look at other places within the regs where we can improve and clarify what our role is as the regulatory board of those. So thank you, is how we'll move forward in building agendas for you for the rest of the year. Okay, that brings us to.
I'm sorry, I think we're confused about that last part about the spectacles.
Okay.
And, can you expand on that?
Okay, I think the question is about the out-of-state electronic commerce. They want just more clarification about that.
So specifically, what is the question?
So what's our goal with having it on our agenda? We just wanted to get an idea. Is it because we want to look if they're compliant or in terms of
So we
inspections
currently
or-
don't have any regulatory authority. So the distribution of spectacle lenses from an out-of-state supplier is not legal in the state of California because there's no regulations on it. So this is looking at the establishment of that business. So I don't I'm not sure who brought it up or who put it on there, but that's just why it would be looked at is because it's not.
And is it just like with contact lenses? Obviously, we follow the suppliers of contact lenses, and that's just to understand like what's coming into the state. I'm guessing.
Right. It's so that we can make sure that the items coming into being distributed to consumers in the state of California are going to be able to be, those companies are going to be able to be regulated.
Okay.
Yeah.
So for example, if
So
you're-
wait. I
they're
just
about
don't.
40.
We're getting into the subject area
okay.
now and the details and the policy, and we'd want that notice so that anyone interested in that discussion can participate. So right now, it's just whether that whole area needs to be researched and then prioritized. So let's just. I appreciate that we want to discuss it further, but I'm concerned about for Bagley Keene that it hasn't been noticed.
We are now at our future agenda items. I know I wanted to express one, but does anyone have a future agenda item they'd like to add?
And other than everything that you guys have already talked about as adding.
All that stuff, put that on there.
Okay.
See above.
Okay. Well, there was one agenda item that we talked about earlier, and that I was looking at the cost. That it cost a dual registered or dual licensed person $700, and that they're being charged for an application fee. And keep in mind, I'm sure you're just requiring one live scan at this point, but the cost is rather high. $700 for them to finish all of that. When you compare it even to optometrist license, I'm not sure they even pay that much. So I'd like that as a future discussion.
This is where you get to. This is
on
a.
that item.
Oh, yeah. Okay. Yeah. Okay. But you all agree that that could be a future agenda.
And so I think that that's right. Exactly as we're going through our regs, we'll take time to go through that conceptual of how much are we charging folks, what is it that we, and then I think also too, our, as Jessica pointed out earlier, our ability for refund is limited really only to spectacle lens, or right, contact lens.
Contact
Thank
lens.
you, and only the application fee. And so I think that that would be as we're going through regs, we'll conceptually group those together and have a full discussion about the substantiation behind the license fee, and then also what then around that we would also consider the appropriate refund sort of practice.
And could we also have staff just talk about how registration fees affect budget for the DOC?
Just to clarify, are you talking about how the fees affect the registered dispensing optician fund? Right. Okay.
Thank you very much.
Thank you. And any comments from the public? No. Okay. I guess that's it, right? We will call this meeting adjourned. Thank you.